Thank you all for coming. My name is David Dye. I'm the Deputy Director of the People with Disabilities Foundation, and we really appreciate the turnout for this showing of our new video and discussion that follows. The People with Disabilities Foundation was founded in 2000 with the mission of providing education and advocacy for persons with psychiatric and/or psychiatric and physical disabilities so that they can achieve equal opportunity in all aspects of life. Within our service areas, we have two program components. One is educational seminars and educational resources, this being one of a long series going back for the past 8 years. And in addition, delivery of legal advocacy and public policy advocacy. Videos like the one that to be shown today and this program take a great deal of time, dedication, and resources. And our seminars and other educational services enable us to reach a diverse audience so we can cast light on a wide range of invisible disabilities. I'd like to introduce three people. What we're going to be doing is having a presentation and question and answer indicated. And so if Monica Eskridge will come forward. She's a former U.S. Department of Health and Human Services officer, civil rights employee. Responsibilities included enforcing compliance with various disability discrimination violations under federal law and regulations, including the Rehabilitation Act of 1973 and the American Disabilities Act. And Aaron Cohen. Dr. Cohen is a clinical psychologist with the Counseling and Psychological Services Center at the University of California, Berkeley. Dr. Cohen conducts workshops relating to students and psychological disabilities involved in crisis intervention, counseling, educational assessment. His research includes self-concept in college students with specific learning disabilities. And third, Stephen Bruce, Esquire. Mr. Bruce has worked for the Social Security Administration as a senior staff attorney. Stephen has worked for the United States Department of Health, Education and Welfare, and the U.S. Department of Health and Human Services Office of Civil Rights. Was a supervising attorney in the Government Benefits Unit for Legal Aid, and was an assistant public defender. He has a BA in Economics and Psychology with honors from the University of California at Berkeley. His JD is from the University of San Francisco School of Law. Stephen is admitted to numerous courts, including the U.S. Supreme Court. And it was in 2000 that he founded the People with Disabilities Foundation, where he is now the executive director and managing attorney. So with that, I will turn it over to the panel.
All right, what we wanted to do, I think we have a cordless mic to let people ask questions at any time without necessarily waiting.
Actually, we don't have a cordless mic.
Oh, we don't have a cordless mic. So if anyone with the...
No, that one's going to pick up the...
So if anyone has a question, please speak loudly, or we'll try to repeat it through this microphone. Let me just say, in making this video, a decision was made by me to use real people as opposed to actors. It was not easy to get people to disclose their mental disability on a national basis, and it did take a long time. However, I really think it was worth it. I think this subject is often misunderstood, and hopefully having the actual employees and employers, it would give more insight into the underlying nature of the psychological disability. I'm going to see if anyone has any questions. This particular video has a panel of experts which are medical, compared with our other video, which is understanding employees and job applicants with psychiatric disabilities, wherein we have a panel of lawyers basically saying what are the rights and obligations of the employee and employer, without really a clear medical explanation as to just what it means when someone says they're manic depressive, or they have OCD or schizophrenia, which I think is the most common type of psychoses, and perhaps one of the most least understood. Having said that, I'm going to ask if anyone has questions. We'll try to be responsive. The lady in the purple jacket.
Hi, I'm Dale Milfe, and I'm Vice President of San Francisco NAMI, the National Alliance for Mental Illness. And so I'm a neurobiologist by profession. So I have a lot of experience personally, professionally, and with our families with bipolar disorder, schizophrenia, and all of these illnesses, which I think the video was great, but our families face the barriers to getting that job, to get it so that they could ask for the accommodation in the first place. Because you get people who often get sick their first year of college and then go through years before they get stabilized and can't get access to a job. So what would the suggestion be, or how can you help somebody? Why should an employer hire you if you disclose that you're bipolar to begin with and you don't have a master's degree yet? Getting that first job is really difficult.
Which of you want to take that?
Well, let me just say this. The question relates to someone who's become ill in college and they want to get their foot in the door, basically, and it relates to whether or not one should disclose, which is a very practical question. It's a good question. It comes up all the time, and it's a judgmental question. As an attorney, I might advise clients not to disclose initially, because the reality is, if there are a lot of equally skilled applicants for a job, whether it's due to misconceptions about the disability or not, they may be lessening their chances of getting the position. However, it is judgmental if someone were to get a job and then immediately hand the employer a list of accommodations and say, I'm disabled and this is what I want, 1 through 10, it's only going to cost you $5,000 or whatever. Then we have a situation which the dynamic may not work out. We may have an employer viewing the employee as one who has concealed something, who they've sat, interviewed, and talked to, and why didn't they say it? There is no correct answer from a legal point of view. From a medical point of view, in one of our scenarios in the librarian felt, she was Ellen with the bipolar diagnosis. She felt it was important to her personally to be honest, because that's the way she is, and it would have been hard for her to continue working without disclosing. So in the end, it's judgmental. There is no right or wrong answer. I think all the facts and circumstances have to be considered, and the person or people that I would suggest consulting, well, in addition to a lawyer, but before a lawyer, would be a voc rehab type person, and the psychotherapist maybe to bounce ideas off of to get a reality check upon which would be most beneficial in the end.
Okay, we have the...
Can I do one little statement on that? Because one of the things I heard out of that was how do you get back in? How do you get back into the gig? And one
Into the beginning.
in the first place. The one piece where I can bring my area in is that, especially with the first example, you said that they had to leave college, and that's so much of what I used to see. I used to work in the disabled students program at Cal. I don't anymore. But one of the things that I saw a lot of, in a real wide range of examples, is students who had their first quote-unquote break, or whatever their symptoms were, had to leave school early in their career, and were now coming back in. And they came back in a real wide range of circumstances, whether it be going back to community college, taking one class at a time, and then coming back into Cal, or whether they had enough credits and they just came directly into Cal. And then we worked with them to provide reasonable accommodations so they could get through Cal and get their education, which is really just at the undergraduate level, which is now kind of the benchmark, the benchmark just to get a basic job. It seems like more and more places are wanting just an undergraduate degree, let alone a master's degree. So I really would encourage, whether it's family, whether it's the individuals you work with, to engage in the process of getting their degree in higher education. Most of all the schools in this area, I believe, have disabled students program. Will work with students on reasonable accommodations. They also then will be able to hopefully try to build some of those skills. At Cal, for example, students will get internships and can kind of slowly figure out what's right for them, and then they have something on their resume to work, in and move forward. And again, everyone doesn't have to come to Cal. It can be a community college. So I'd really look at that piece of it as well, even before thinking about a job.
So that helps. We're going to take advantage. We're going to take advantage of Patricia Finnegan, who's here from the EEOC. She was also the mediator in the videotape scenario, to answer the question with respect to the employment issues and when to disclose.
Actually, and also about how to get back into the system. If you kind of dropped out of the system late in high school or early in college, and I thought Karen's comments were very well taken. But there are job developers, and there's some of them in this room, who specialize in serving people with disabilities. Some of them specifically mental disabilities, in terms of getting back being able to get, a job in the first place, or being able to develop skills. And I, in addition to working at the EEOC, am chair of something called the Disabled Opportunity Council, which actually emphasizes federal employment. But we network with a lot of job developers who come to our organization. So I'm going to say that someone who has just been sort of out of things and not doing anything since they were in school probably needs to become a client of the Department of Rehabilitation, probably needs to see to get hold of some kind of job development service to learn skills and find access to jobs, because trying to get from outside the network in is a difficult thing. And then that doesn't necessarily mean that they would be disclosing to the employer initially, unless they needed a reasonable accommodation, that they have a disability. That's always a discussion that you have with yourself, essentially, in terms of just how visible are your symptoms, how much accommodation do you need, versus do they really need to know that. So, but I don't think your question was really about disclosure. I think it was really about how do we get jobs, right? So, I don't know how open a forum this is, but there are job developers in the room who might be able to speak to this as well.
Okay, did that answer your question? Okay, is there anyone else with a question? I don't know if this is going to work, so if you could just speak loudly. Okay.
My name is Anna Miller, and I work at Kaiser, and we do have employees who both have disclosed their disabilities, and then those who obviously have a disability but haven't disclosed and will not disclose, and yet they're acting improperly. And so my question is, what responsibility does the organization have with regard to those employees who are acting, whose conduct is improper in the workplace? We know something's wrong with them. They will not tell us, even though we've provided a number of opportunities. So what do we do?
Okay.
Do we have the right to terminate them based on their unprofessional conduct?
Like the lawyers in the house.
Let me say that I've been asked that question often employer, from the supervisors who are having, from their point of view, a problem with performance, or they so articulate, and they know that there's no duty to disclose. And even when I was down at the VA in Palo Alto talking to them, they even knew where the chart was on the individual, but knew that they weren't supposed to look. And it's an interesting question, and Patty Finnegan from the EOC may be able to shed some light on this. But I think that individual, the manager who's in a quandary like that, needs to talk to HR, because there's another concept in disability law, and that is if you're on notice or believe that, even if it's a false perception, but believe the person is disabled, whether or not they really are, there could be some legal obligation. So it's not always clear what to do, but I think it's important for the employer under those conditions to really find out. I mean, if they already are under legal obligation, just based upon how that question was phrased, that they know this person has a disability. That could be the equivalent of the employee having disclosed the disability. Patty, did you have anything to say about? I mean, it's a common question. It's not an easy one, actually, from the employer's point of view. Patty, maybe we need you up here. Help us answer some of these questions.
So, okay, is this working? Yes. Okay. Doesn't sound like it.
Let me do a sound check. Are the people in the back of the room having problems hearing? No. No? Okay. If you are, just move forward. I see there's. Don't be shy. That's the instant answer to the issue. So if you're having problems hearing, please move forward.
So, the lady from Kaiser, the first thing I'm going to say, and I'm going to say that I am considered a disability expert at EEOC in a legal sense, but I'm not an attorney. And I'm going to say that your question is a very individual question. And when you say, we know that somebody is disabled because they're acting improperly, it really depends upon what you're seeing an individual doing, and if you perceive, I mean, if somebody runs screaming down the hall, and you're going to say, you know, like a layman, that person, there's something wrong there, or whatever. But in fact, if what you mean is that somebody has, you know, behaves very improperly such that they disrupt your workplace, or they do acts of misconduct in terms of the way they're supposed to be with customers, things of that sort, and they don't respond when the supervisor counsels them and stuff like that. Number one, some people have disabilities they don't know they have. Okay, because I mean, for example, I've had somebody come to me who discovered that he had a psychiatric disability because he was having a lot of trouble at work. He couldn't figure out what was wrong. He went and got some tests from a psychiatrist and was diagnosed with something. And then tried to get the employer to accommodate him, and they proceeded to use it basically to torture him and mistreat him. So, you know, some people may know that they have a disability, a mental, psychiatric disability, but not trust the employer to accommodate them. You may perceive that somebody might have something going on. Now, if you think somebody needs some help on the job, it might involve a reasonable accommodation. You can enter into an interactive discussion with them by saying, you know, I perceive that you're doing this and this and this. Is there something going on? Is there something we can help you with? Is there some way we can help you, you know, do better in your job? And all kinds of things could come out. Maybe they're just having personal problems at home. Maybe they're going through a divorce. Maybe anything can make people temporarily seem to you as if they have a disability. Or in fact, it may be real and there may be things that you can do. But you can't force people to disclose their disability to you if it's not obvious already. And you know, you can't do that. And on the other side of that, you don't have to tolerate any kind of behavior, no matter what, any kind of misconduct, no matter what it is. And I'm being long-winded, but I hope that answers your question, because your question was very general.
Patty, can you also address the definition of qualified disabled person with respect to being perceived as being disabled?
Yeah, you can treat somebody in a particular way, or we find sometimes that people get discriminated against by employers at EEOC because they don't have a disability, but the employer perceives them as having one. They're being regarded as having a disability. So that is something that you need to be careful about. If somebody doesn't have you get to regard me as having a physical disability. Okay, you can see it. It's obvious. You know what's going on. If that's not the case, if there's nothing visible to you and you're just making an assumption as an employer, you can violate the law and discriminate against a person just by regarding them as having a disability, even if they don't.
Thank you.
Is there another question? Tell you what, let's get one from this side of the room, the lady in the back there.
Okay, my name is Karen Valeria, and I have just a legal question about at-will contracts with organizations. My experience, having worked at places within the San Francisco community for many, many years, I always had to sign an at-will contract, which in my mind meant if they wanted to let you go, they could indeed do that. So what kinds of organizations have at-will contracts and what kinds do not? I mean, I know the feds don't.
Okay, let me ask you to do this. Can you tie it into the topic today with respect to the employment issues?
Into the employment issues?
For persons with mental disabilities. You're talking at-will contracts. That's, for me, I don't really know what that means. That's real general. If you can pinpoint it or narrow it down a little more for us.
Okay, that makes sense. I think that it just meant that if one did not perform up to standards, that one person, regardless of his or her situation, could be terminated. So, you know, I realize that that's sort of going off guard from what we're talking about in terms of disabilities.
So are you asking then, is it discrimination if it's a person with a mental disability who's under an at-will contract? That's kind of where it can go a lot of different ways. Are you saying then does the employer have an obligation to accommodate that employee rather than just say you're at will and you're out of here?
Yeah, because I see a huge differentiation between what you folks are saying related to, you know, it could be racial discrimination, it could be disability discrimination, it could be a number of discriminations. And the other
which is
part,
the smoke screen.
Yeah,
the at-will part of it is the smoke screen for the discrimination.
We just don't want you here.
Okay.
So therefore, hasta la vista. I don't know. I mean, I realize it's a legal question and maybe not.
Well, let me say that because I've been asked about at-will a few times, and I can't give a definitive answer except to say that every job is at-will to an extent. No employee or employer have to stay together. Anybody can quit. And that's really not just in California, that's all over. And I think if you do a legal analysis, it's really going to come down to the same thing. I mean, is this individual subject to some kind of disparate or differential treatment based on the protected category? In this case, it's mental disability, but whether it was race or ethnicity, it wouldn't make any difference. When people ask me about signing an at-will contract, I just say, first of all, I think all jobs are really at will, and I don't think it's that meaningful. It sounds like an area subject to some kind of abuse, but from a legal point of view, I personally don't think it means anything. That's not a professional opinion. I think we all know that anybody can quit a job. There are no servitudes. And everything is sort of at will. So I think it's a matter of, is this a mechanism being used to exclude an individual or group of people based upon a protected category? And Patty?
I'd like to add a little bit. I see a lot of charges of discrimination at EEOC where one of the first things that the employer does in response to the charge is say we are an at-will employer. And that's all fine, but you don't get to use that back to fire somebody because of discrimination or mistreat them for discriminatory reasons. So it doesn't mean anything in this context. Steve is absolutely right, I think.
Okay, before we go to the next question, I do want to acknowledge Jim Mayer of Ideas in Motion as the producer of this video, who worked very hard along it.
And I'll take this opportunity also to acknowledge everyone who was involved with the video, all the people who volunteered their time and effort and worked to make the video a success and to come out with what I think is a very good product. Thank you. The question over here.
As a practical matter, a small employer usually can't support a large human resources organization, so they're not going to have some of the options that a larger employer has. And being a small business owner in the past, I mean, you're working 12, 14 hours a day as it is. What can a small employer do in a situation when they're confronted with some of the examples that have been discussed?
Well, under the ADA, as with the predecessor laws, the Rehabilitation Act of 1973, undue hardship has always been a defense. And I think a lot of comments have been made in the context of it being unfair to a small business, whether it be architectural modifications or what we're talking about today. Under the ADA, there is a numerosity requirement. It's 15 or more people. Now, under state law, and it varies state by state, it's less, but I think that the primary two defenses is any kind of undue hardship, whether it's a small business or a federal agency, so says the Supreme Court. They can have undue hardship. And it's not a realistic situation to believe that a small business would have to jeopardize their, functioning as a small business to accommodate someone. And I think that's sometimes misunderstood. It's really always been sort of built in to the law. It's always been set up like that.
Okay. This one here.
Yes, I have a cat who's an emotional support animal, and I like to take him with me to a lot of places I go to. But I heard emotional support animal is not recognized by the ADA. Is that true? And with my doctor's note, am I allowed to take him with me sometimes to work?
We're apparently having a panel discussion.
Let me say that about service animals. California does have a service animal provision, and each county, could get a service tag for an animal. I don't think there's any one answer to that question. I think you have to, the word in the adjective in accommodation is reasonable. It would depend on the facts and circumstances. I mean, if there's any disruption, et cetera. I don't think it's a yes or no question. Service animals are, not just because they're licensed in California, but certainly they're permitted to accompany someone to work so long as it's reasonable and doesn't interfere with operations, et cetera. So I don't think that question can be answered in the abstract.
Okay.
Do you-
We're gonna
do you
go back on
have-
this side of the room.
I'm sorry.
Yeah. How about the man in the red shirt?
Hi, I have a additional comment and then a question. I'm Clayton Yee, and I'm with JVS, Jewish Vocational Services, and we are one of the job development organizations that work with the Department of Rehab. So this kind of in reference to the lady from NAMI who asked the question, how do the people with disabilities, how can they break into the workforce and find that first job?
What's your agency again?
Jewish Vocational Services, JVS.org. And to add on to what Patty was saying, that one place to start is with the Department of Rehab, because they work with individuals with disabilities and provide assessment. And after that assessment process, they work with job developers like ourselves to help people with their job search. So if anyone's interested in finding out more, please speak to me afterwards. And then the question I have for the People with Disabilities Foundation is, what are your plans to make this video available, say on YouTube? Because I feel like a lot of the workforce specialists at my agency, as well as employers, could really benefit from seeing this video and having other educational resources like that.
Well, our policy is to have wide and diverse distribution, and as soon as practically possible, we do want this downloadable from the internet, without having to go through the process of placing orders and sending it in the mail. I mean, whether it's YouTube or somewhere else, that is our plan. And we do expect it to happen. I can't tell you when.
Okay, I've been told we have about 5 more minutes, so let me ask you to go ahead and give us your question.
I'd like to answer. What's your name? Let's see, Maria. Maria Casas. My name is Chakanda Egan, and I'm an attorney representative with, I work with Steve, who's doing Social Security for over 27 years, representing clients with different types of disabilities. I am legally deaf, so I can answer some of your questions, Maria. I also represent the transit, that's Caltrans, Samtrans in San Mateo County. I represent the deaf population and do sensitivity training for over 25 years. And your questions, we have addressed it very much. I have a hearing dog. She's not with me today because she's now 16 years old. So she doesn't like to go out anymore. And she's been wonderful, saved my life twice, and I don't have time to tell you about them. But the laws have changed very much. It used to be that when I got on a bus, I had to show my dog's license, which I still carry. They changed that. I cannot tell you how long ago it was, maybe in the last 4 or 5 years. Because when we do the sensitivity training, the bus operators are not allowed to ask us if they're a service dog. Now, they can do it, because there's a lot of people are bringing animals and saying they're service dogs or emotional this, and you're allowed to bring them into the bus, okay, or the train, whatever, is going to disrupt, and they're well behaved. But in a work setting, you're not allowed. And I know that for a fact that I used to go to San Mateo County. I retired from San Mateo County, and you don't know what I went through. Like I was telling this young lady, Linda, she's lucky that the service is up for her, because I had to struggle like 80 years ago. And I got challenged many times because people had allergies or they don't like, they said my dog stunk, which he didn't, whatever, you know? And so at this time, you're not allowed.
Okay, and if you guys want to get together afterwards, that's great. I think we have time for one more question. The woman all the way in the back.
My name is Shelley Samuels, I work at JBS Educational Schools.
I'm sorry, I can't hear you
Okay,
here.
my name is Shelley Samuels. I also work at Jewish Vocational Service. My question relates to clients. I work with clients, and sometimes they either are at a stage, they're either not diagnosed with something, or to put it in the form of a question would be, if somebody is aware that they have been diagnosed with a progressive type of illness, where at the moment, currently, they are not manifesting any symptoms, but they anticipate that maybe within 3 months, 6 months, or a year, symptoms may appear and may create the need for an accommodation in the workplace. What would be your recommendation to them beyond an initial hiring screen of whether they should disclose, how, or at what point?
Okay, I'm just going to take that, make it real simple. At the point when they need the accommodation.
Well, that's the point. They don't know.
Right, but at the point when whatever the degenerative issue is starts to manifest itself, then I would say that would be the point at which they would have a better idea, one, of what the manifestations are, and two, the types of accommodations they would need. And I'll turn it over to anyone on the panel. Patty, did you want to add anything to that?
No.
Yeah, I think maybe what you're asking is when you know something's going to happen, how do you really prepare for it? I mean, if you know, there is any way to prepare for it. I think Monica's correct from a legal point of view. You're either a quote-unquote qualified disabled individual who's entitled to an accommodation, or you're not. In terms of a progressive situation, there have been cases litigated where somebody with multiple sclerosis or other type syndromes, and of course we're getting a little bit away from mental disorders, except to the extent that they are becoming progressive, or maybe medication has been dropped or something. I think it's good just to consult with your job developer and to find out the rules. And a lot of it is judgmental, as I said in response to another question. It depends who the employer is and how important the employee's services are, and there is no one answer to that. But I don't think that there's any legal obligation that's incurred, certainly, but in preparation, it's going to vary all over the place.
Depends on what your individual situation.
It depends what the situation is, because you read cases where you have someone with MS, multiple sclerosis, who they never say anything, but when they're using the walker, at some point in time, the employer is going to be on notice, and then their legal rights will take effect, either when they disclose or when, as Patty Finnegan said, they're regarded as. And it's really, I think, an individual thing.
Yeah, and I think one of the things we really know is that with psychological disabilities, symptoms, peak and, go up and down. And so I think the one thing that's really important for those of you who are working with these individuals that maybe are now currently stable on their medication, they're doing very well, or someone who knows February is a really bad month and that something might happen, that you may wait to ask for the accommodation, but that you're preparing and talking to each other about what you may anticipate and how it may be to talk to the employer, so that it doesn't, all the stress of it doesn't happen all at once, because that's going to be very difficult. So at the least, what you can be doing with the individuals that you're working with, or if you're thinking about engaging this, if you have a psychological disability, is preparing yourself in your mind about what it might look like. When your symptoms get really bad, when you have medication side effects, what does your performance look like, so that you can anticipate some of the issues that may come up?
Could you also talk about the medication and changing medications and somehow how that can impact a person's ability to do the job?
Well, the question was, can I also talk about how changing medications and switching medications can impact the individuals doing the job? And yes, it can. I think that's another thing, is that we have to anticipate that when an individual switches their medication or maybe increases their dosage or tries a new medication, that again, it's in the same light that you're going to want to anticipate the individual, or if you're working with the individual, is going to want to talk to the psychiatrist about what that might look like and how that might impact the job, and so on and so forth. I know at Cal we did a lot of accommodating for medication side effects. And so the individual was actually, the symptoms were controlled, but we ended up accommodating the side effect of the medication and what we decided to work with a student on. So, that is something that is definitely needs to be thought about.
Okay, I'm sorry we have run out of time. We're ready to close up.
Yes, let's just thank our 4 panelists, Monica Eskridge, Dr. Aaron Cohen, Stephen Bruce, and our impromptu panelist, Patty Finnegan.